Hello, and good morning, evening, or afternoon, depending on when you are watching this, the latest episode of Edie's Susty Talk series of video interviews. After starting out with keeping sustainability professionals feeling a little bit more connected to each other during lockdowns last year, we're now taking the opportunity to interview some new voices ahead of COP26. And I'm delighted to have Magnus Boyd on the line with me today. He's a partner at law firm Schillings and he specialises in reputational protection. So hoping to explore how that's evolved to focus more on climate and environmental issues in recent years. So thank you so much, Magnus, for your time. How are you?
I'm great, thank you, and thank you very much for hosting me.
No, thank you for sparing the time. I appreciate. I'd say it must be a busy time of year, but I presume it's always a busy time in reputational protection.
I guess, yeah, it is, particularly in this area, and particularly in the run up to November, of course.
Of course, and from what I've been briefed on about your career, I know you've been working in this field for some time. So I wanted to ask really whether you specifically chose to focus more on the climate and environmental part of reputation, or whether business approaches and business law has just evolved naturally over the past couple of years to make that of more importance.
It's a bit of both. We are sector agnostic as a firm, because reputation permeates every sector and every business, and it's really crucial. And that's obviously probably a theme that we'll develop through this talk. But over the last couple of years, increasingly corporate reputations are being assessed by by pegging or in relation to environmental concerns, and that's certainly because of a degree of public pressure and increasing public interest. Again, another theme that we'll touch on, I'm sure, through this talk, and increasingly, regulatory authorities globally. But I think but also, particularly this year, we've seen some really interesting developments in the law itself around this area. So I think it's a combination of both the law developing this area, or an increased level of protection in this area, coupled with this being seen increasingly as a reputation risk, not simply an operational risk or a business continuity risk or anything of that sort.
For sure. And you've mentioned there some of the things that are often raised in conversations about what is driving businesses to do more on environment and say more on environment. So you've mentioned a shift in public mood, largely driven by new science and new communications and changes in policy. We've also seen changes in investor demands and increasingly investors describing themselves as activists. So is that something you've seen as well? And I know it's hard to pinpoint one, but is any one of these the biggest drivers, or how do they relate to each other?
I think it's probably more helpful to look at how they dovetail with each other than to sort of list them in a kind of priority, because at any one time those priorities are shifting. But you're quite right that there has been, over the last 10 years or so, we've seen a rise in activist shareholding, and in a number of, not simply a number of areas, but a number of what I call tactics or strategies for those activists. And obviously in the last year, we've seen with at BlackRock, for example, those investors going in and pinning their flag in the ground of environmental sustainability. That's really interesting, but I think it reflects that's more reflective of the public mood than driving the public mood, if I can put it in that way.
Right.
So, yes, so the various things in play at any one time. I think, I feel quite strongly that this shift in perception, particularly in boardrooms and at C-suite level, of environmental concerns not simply being operational or any of those or more commercial, but actually reputation issues, that I think has been the biggest shift, because in other areas of corporate life, these things are easier to assess. You can see you can measure rises and falls in share price value, for example. You can look at there are all sorts of key performance indicators, whether you're a B2B business or a B2C business. But the thing that I think people are most concerned about is reputation. And the reason for that is, at least in my experience, is that it's invidious. It's that, reputational damage is very often difficult to see or hear or measure, but you can feel it. So the classic thing is, customers don't call you to say they're no longer going to work with you, or they're no longer going to buy your products because they're unhappy about your environmental profile, for example. They just move, they just shift. And very often you only start to see that damage sometime after or you only get to see the impact of that damage, rather, sometime after the whatever the event is that caused it. So for that reason, I think people are very rightly concerned about the invidious nature of reputational damage as it attaches to these kinds of issues.
And I wanted to build on that, really. You talked about how this has gone from being sort of an in-house risk, so something that's just material and just in-house, to something that's reputational. And there's been discussions lately about businesses not only using their scope 3, so their value chain, but their scope X, so their whole impact on the economy and society. So as well as that reframing of where the risk sits, do you think there's a reframing of how promises sit as well? So going beyond just best case pledges for in-house, for example, and towards shaping industry practices and public action?
Well, again, as a lawyer, I view all these things through the prism of the law. So for me, the seismic shift here was the judgment in May of this year in the Dutch courts against Shell, where as you know, the Dutch courts said that the targets that Shell had set for reducing their greenhouse gases were too opaque, and simply stepped in and made an order that said Shell needs to reduce its carbon emissions by, I think it's 45% by 2030, which is an absolutely astonishing order by a court for a start, but the significance is far wider than that. That is the court saying, that is the court directly intervening in environmental and sustainability concerns, and that figure, adjusting your model by, or reducing your emissions by it. Shell obviously had targets, but to be under a court order rather than simply whatever you're professing or putting out to the world as a target that you hope to achieve is entirely different, and will affect that the entire company, I'm sure. Plus, it's just a huge figure, 45% within, 9 years.
Of course, and I mean, time will tell on that one, seeing as that Shell has actually said we will challenge that. But I feel like, as you say, the precedent has been set. Other businesses are now aware that a court can and might do this. Very real.
That's right. And actually earlier in the year there was another decision against Shell, but Shell Nigeria in this case, where a Dutch court, and this was the significant thing, a Dutch court upheld or held that Shell was responsible for the damage done to Nigerian farmers due to leaks in their oil pipes. Great. And it's established, but the key from a legal perspective was that Shell, or the courts were imposing an order on Shell that affected them beyond the jurisdiction of that country. It was so they're imposing a duty of care overseas, and that's also novel. So we're seeing all sorts of ways in which the courts are really in effect driving, not just driving regulation, but driving legal change as well to push corporates into the right sort of behaviour.
Of course, and I wanted to talk about that a little bit more. Essentially, whenever we put out a story that has something about a big net zero pledge, and specifically if there's been a lot in a particular week, we get asked, well, how exactly are these being tracked? How are these businesses being held accountable, especially if they haven't been held accountable on previous missed targets? They just get put in small print in a sustainability report. And you mentioned there the importance of court orders and single decisions there, but I wanted to get your view, obviously, as you mentioned, through that law lens, of how that might also intersect with policy making or shareholder action and other ways to hold corporates accountable.
I guess the law impinges at the short answer to that question is perhaps that so for example, to cite the Shell case again, the May decision, that the court was holding Shell to account on the basis of its 2019 figures. So it was looking at it. So it was taking Shell on its own record and on the data that Shell was providing itself. But the courts have also intervened, not simply on a sort of horizontal level, against corporates, but also from a sort of top-down level. We saw that in Australia, in fact, only last month. Again, you'll probably be familiar with the Australian decision to impose or to recognise. So this was the Australian courts effectively holding the environment minister to account and saying, you as an environment, whoever the environmental minister is at any one point, has again a duty of care on the children of this country to ensure that they do not suffer or are injured in any way by environmental damage or environmental concerns.
Yes.
So the courts are stepping in, I guess, both in a sort of against corporates, at a sort of we call it a sort of horizontal level, so where one party is suing another party, but also in this kind of vertical way, so imposing a duty of care from the top down. And then that can obviously be judicially reviewed and so on.
So I wanted to build on that. Some super interesting cases you mentioned there, Magnus, but I think a good question is, how do you determine where the buck stops and who is responsible? So businesses don't exist in a vacuum. It won't just be Shell. There'll have been someone else that probably did the engineering and construction for its project, and that's not even to mention suppliers and technology memorandums of understanding. So we often talk about the importance of collaboration in delivering a sustainability strategy, but how does that get split when it does go wrong, and when this responsibility needs to be upheld?
That's going to be the challenge, I think, on all fronts. In terms of, so if you're a corporate entity like Shell, the challenge, as you've rightly identified, is that you are being held to account for a number of procedures or a number of operations that may not necessarily be entirely in your control. Contractually they may be, but on a sort of day-to-day operational basis, those could be where you end up being vulnerable and where your reputation is damaged, because the headline will always feature the most interesting or the biggest player in that in that operational chain. So Shell, for example, may end up being in the headline about an environmentally damaging event, for example, but as you've rightly identified, if you go down the you know, who is actually to blame and who from a legal perspective is actually liable, it may not be Shell at all. So that's another area where the environmental issues kind of really get messed with in terms of both the environmental issues, trying to separate or tease those out from the reputational issues. That's the difficulty for them. And then from again, the other challenge is going to be that's probably going to be the area where, again, where big organizations, where there may be fault, where there may have been environmental damage, for example, will say, well, it wasn't us, it was somebody far down the food chain, if you like. So the liability doesn't rest with us, it rests with something, you know, an entity that's much smaller, that may not therefore be appropriate for suing or litigating against because of its size. And so therefore we may not be able to hold people to account for the environmental issues that they're creating. That's always the kind of the battleground in this area.
Great, well, thank you for that overview. As you mentioned, that is an overview and there's more to be said.
Sure.
Clearly, but for today that's all the time we have, Magnus, so thank you so much for taking the time.
Pleasure, thank you very much.